Excellent. All right. Welcome to Let's Learn Policy 73, Intellectual Property. My name is Catherine Arnold, and I am currently the policy coordinator for the Graduate Student Association here at the University of Waterloo. So, of course, this session will only cover intellectual property and its uses, specifically determined by Policy 73 and as affecting you Waterloo students. But we can talk about where to get other resources in terms of intellectual property in general in Canada, and abroad if we have questions related to that, but that will come later. First, let's get a good grounding in Policy 73. So, the University of Waterloo combines world-class research with a unique creator-owned intellectual property rights policy to foster an entrepreneurial environment that drives innovations from the lab to the marketplace. So this is a quote from the Waterloo Commercialization Office website. So this is a really intellectual property tends to be bigger here at the University of Waterloo than at other universities across Canada for a number of reasons, and we'll talk about them in general, but it lends itself to the overall spirit of Waterloo. So intellectual property and the student being able to own their own intellectual property here at the University of Waterloo is why our startup culture can be so big. It's why our entrepreneurial programs are so well founded within our community, and it is a very core aspect to Waterloo engineering as a whole. So, not just Waterloo engineering, but Waterloo innovation as a whole. So we'll go through a number of things today. So my agenda, I've got an introduction and just to generally what is intellectual property and why is Waterloo special. And then we'll talk about Policy 73 really briefly. I don't want to go too deeply into the pieces of policy. I just want to talk about application to graduate studies and just helpful information for graduate students trying to navigate intellectual property. We'll talk about intellectual property in research, and this will cover intellectual property in your thesis and commercialization of your research, or your other projects developed here at the University of Waterloo. And we'll also talk about intellectual property in coursework, and that's related to the courses that you take, but also the courses that you teach. So graduate students as TAs, and sometimes as opportunities as instructors or sessional lecturers will own the intellectual property in their courses that they teach. And so there's some fun intellectual property rules and regulations about that as well. And then we'll cover a little bit where to find more detailed information on all these topics in the university community. So what is intellectual property? So according to the policy, intellectual property refers to any product that the law protects from unauthorized use by others. This means that intellectual property cannot be used or shared without the owner's explicit permission. So intellectual property is a paper that you write or a prototype that you build or a method that you develop. There is a strict legal framework for the approach to IP rights based closely on the copyright, patent, and law, but that is not where we're going with this. We're going to talk about intellectual property within the academic community here. So what sets Waterloo apart? So IP at Waterloo, as I said right at the beginning, is creator-owned, which grants IP creators with full right of ownership with some exceptions, which we will cover a little bit. But from its inception, this quote is from a paper from 2011, and the paper is called "Does Inventor Ownership Encourage University Research-Derived Entrepreneurship?" And they highlight several aspects of the particular entrepreneurial culture that we've developed here, that we've fostered over many years at the University of Waterloo, and highlight specifically our approach to intellectual property. From its inception and unique among Canadian research universities, Waterloo adopted a policy that all inventions, not explicitly the property of a sponsor, were owned by the inventor, with the sole requirement that all inventions be disclosed to the university administration. And so this is explicitly written in our IP policy. You own your property. You just have to tell the university that you have developed the thing, and then the university is like, okay, you have developed this thing and you own it. And with some exceptions, but there have been a lot of studies about entrepreneurial access, support of support of technology developed at universities. And one of the metrics that measures how well a university commercializes or develops product or contributes to the economy is they'll value how much IP the university owns or the university co-owns with the researchers at the university. And so Waterloo as an institution has notoriously been severely undervalued in these ranking systems because many other universities, when you create something and you work there, they own part of that. So here at Waterloo, Waterloo's like, no, we hands off, like you own your IP, you get to determine what you want to do with it. And that's really, there's a very unique community within the within Canada in terms of supporting creators, supporting startups, and supporting researchers and owning their own IP. And it really sets Waterloo, like as a school, just lower in the rankings and undervalues just the startup and entrepreneurial culture that Waterloo has built. So our IP is really integral to the reasons why some grad students and some researchers will come to Waterloo because of our IP policy and the way that we have the creator rights like built into our framework. So really briefly, application of policy 73. So I'm going to take this slide to do two things. We're going to talk about application of the policy, and I'm also going to show you where to find the policy. So if you go to the Secretariat website, and you go to policies, procedures, and guidelines, and under policies, you will be able to find policy 73. You can search for it alphabetically, in which case you are looking for intellectual property rights, or you can search for them numerically, in which case you're looking for 73. Also, if you just Google Waterloo policy 73, it's usually the top result. And you will be able to find a lot of detailed explanation on everything that we're going to cover here at a high level. And so if you're interested in seeing the true policy words behind some of the points on my slides, you can go find them there. And also, as this presentation is being made in 2022, when they eventually update the IP policy, if that happens, and my presentation is a little bit outdated, you can always find the most up-to-date reference there on the Secretariat website. So importantly, the application of this policy is to all members of the University of Waterloo. And I have down here, it should be noted that individuals who are not Canadian citizens or citizens of a country in which there is international copyright convention, then you may not be protected under Canadian copyright law. And so basically all this says is that the intellectual property rights that is guaranteed by the University of Waterloo in policy 73 can only be guaranteed as long as the country where you are a citizen also has copyright laws. If you are unsure about whether or not your country has copyright laws, that's something that the Copyright Office can help you with. And we can talk about where we can find that information later as we go. But for the most part, this covers all members of the University of Waterloo. So in terms of the intellectual property rights, as I've said before, the creator owns their IP with three primary exceptions. And so we'll talk about the exceptions in terms of sponsored research. And we'll talk about the exceptions in terms of academic content. But one exception that I want to highlight here is that the university retains ownership of the IP in works created as assigned tasks in the course of administrative activities. So if you are a staff member and the university asks you to make a poster, you don't own the poster. The university told you to do it, they assigned you the work, they paid you to do it, they own the poster. That's basically the main exception to policy 73, is if you are doing work assigned to you by the University of Waterloo for administrative tasks, you don't own that IP, unfortunately. So your main obligations under policy 73, and this will apply to really anything that you do, be it coursework or a course research project or your ongoing research or a startup or a course that you teach or a course that you take, is first and foremost, you have to acknowledge contributions. So this is also highlighted prominently in academic integrity, but that it involves proper citation and recognition of contributions. The second one is sharing of proceeds. So the University of Waterloo expects that all intellectual contributors should be entitled to share in the proceeds unless willingly waived through informed consent. So you need to make sure that your partners in developing whatever method you've developed, that if you try and commercialize that method, that they're aware. So if you're working on, for example, like your capstone project that a group of 4 will work on in their final year of undergrad, one person can't take that project and profit off of it without informing and getting the consent of the other people involved. And then, as I mentioned at the beginning, disclosure. So you must inform the Vice President, University Research International, of your intent for your IP. This usually is done through your supervisor and their declaration of IP that they're working with. So I would definitely, this is something that you would work with through your supervisor. So if you're sitting here being like, oh, I don't think I've ever disclosed my IP before, should I get on that? Maybe bring it up in your next regular meeting with your supervisor. Just I know that I'm obligated to disclose my IP. I just want to make sure that I'm doing that properly, and they should be able to help you with that. And then the last principle under policy 73 is obligation to others. So it's the respect of the IP ownership of others. So it's very much recommends not to use pirated books, not to use pirated software. You want other people to respect your IP, so you should respect theirs in turn. And that flows very cleanly also from acknowledging contributions. So using proper sources and then citing them properly. So we're going to talk a little bit here about your intellectual property in your research. And so here is exception number 2 in terms of, do you own your IP? And the second exception to yes, you own your IP is if you have a contract or industry sponsored research agreement where at the very beginning of the research, the company said, we want to own the IP, and that is part of the research contract. So this research agreement with an outside company may set some requirements on IP ownership outside of policy 73. And again, your principal investigator, who is often your supervisor, will know and should inform you about any IP contracts. So I started an industry project when I joined in my master's degree, my master's of applied science. And right away, I was told by my supervisor that while I was going to be working on new IP, it would be at minimum co-owned by the company we were working for, and they would have they were promised first opportunity to purchase. So if I wanted to sell my IP, I had to ask them first before I went more public with it. And then if I wanted to patent anything, they got a free use of the patent. So I could patent it and I could lease that patent to anyone, but they had free access to the patent if it was patent. And so that was a number of like IP conditions that we set out in the research contract, where I did not completely own the IP I was working on. It was co-owned with the outside company. One of the main principles of company-sponsored research at the University of Waterloo is that you retain publication rights. Not only do you retain publication rights, but if the contract with the outside it specifies that your IP must be protected or secret, then the funding that they give must enable public research. So the principle is that we are a publicly funded institution and we do public work. And so if we're going to be doing private or secret research, then the funding and sponsorship from outside that does that public or secret research must also enable public research to be done that can be better all of the community. And some other research relevant policy 73 principles are that students are the first authors of publications based on their thesis work. So if you're able to do any publications as you compile your thesis, then you get first authorship on those works. Financial support is not sufficient on its own to merit authorship credit. So if a company sponsors you, you don't need to list them as an author on your publications, but that you are traditionally expected to recognize their support in an acknowledgement section. So you will see acknowledgement sections recognize NSERC funding, government funding, tri-agency funding, and then you'll also see acknowledgement sections recognize government grants, company research grants, things like that. And the legal determination, this is a big thing for academics. So in academia, especially when we're writing papers, we will like rank the contributions of someone to a paper, and then that's the order that their name appears on the work, right? So I'll have my name first as a student, and then my postdoc who helped me will come second, and then occasionally I'll have an industry partner advisor come third, and based on the contributions to the work at hand. The law doesn't care about how much work someone put into IP, and IP right is not based on merit or extent of contributions. If they helped, and therefore the law considers that they get IP, and that's important to consider in terms of generating your IP. And then again, you are required to report your IP to the Office of Research. So intellectual property and research, but specifically in terms of writing your thesis. So in writing your thesis, the Copyright at Waterloo office recommends that you use content with an open license or in the public domain, in which case you're not really infringing on anyone's IP, that you ask permission to use content, and that you acknowledge contributions. So all of this comes out of that fourth obligation that the IP policy sets, and that fourth obligation being to respect others' IP. And so if you have a figure or an image that is particularly valuable from a paper that you found that really influenced your work, you think it's perfect for the background of your thesis, traditionally, it is expected that you ask the journal permission to publish that diagram within your thesis. And further acknowledging contributions, many people will build a thesis out of several publications over the course of how many years they are working at the University of Waterloo. For example, I finished last semester a paper that we called the problem formulation paper for my thesis. And the problem formulation chapter is basically done. I'm going to take this paper and put it into my new LaTeX document, and it's gonna be good. Minimal work required in order to incorporate it. But this means that I must acknowledge the publication that published that paper, and that I have to declare that that work was done outside of just my thesis. So it is common for publications throughout your degree to be used as chapters in your thesis. So some publishers may require that you do ask for permission to use your own work in your thesis. They usually have websites indicating privacy and permissions, or often there will be an agreement before you publish your paper, in which it will say you can use this or you can't use this without permission. And then regardless of how you get permission to use your paper in your thesis, is expected that you include a contribution section in your thesis that just describes the different publications that have now been incorporated into your thesis. So I expect mine to look like a table of different papers, and where they can be found within my thesis. But just again, this is just respecting the IP not only of yourself but of other people as you write your thesis. And the Copyright at Waterloo office would love to help you through this process if you have any questions, and I've got a contact email for them at the end of the presentation. Commercialization, and this is the big thing for a lot of people who have especially chosen Waterloo for its startup and entrepreneurial culture. So you own your IP. Now what? So the idea is you've developed a perfect solution. Say you've solved sunburns forever, and you want to commercialize your project and make money off of it, or sell it to investors, or revolutionize skincare. What do you do first? So often what you're going to be trying to do is seeking patent protection. Patent protection basically means that you have the right to your solution, you own your solution, and no one can take that solution away from you or start making money off of it independent from you. And there are 3 ways to go about getting patent protection while you are here at the University of Waterloo. And the first is to personally file your own patent. The second is to independently retain legal services to file for a patent. And the third one is to engage with the Waterloo Commercialization Office to discuss having the university assume and pay for patent filing. So the University of Waterloo has an office that is specifically there to help walk people through the process of patent filing. And this can involve considering a lot, like the different contributions within your community that helps you work on this project, as well as the novelty of your project. And the Waterloo Commercialization Office doesn't require that you use them to file a patent to talk to you. So you can go there and without committing to having them file the patent for you, learn about the process and understand what the obligations are and what the possible outcomes are. And so if I had to make any recommendations to a student who is hoping to pursue commercialization, I would say step one would be to engage with the commercialization office just to get a feel for what's ahead of them. And if you decide to pursue patent filing through the university will assume and pay for that patent filing. So they will deal with all of the paperwork. They will handle all of the fees associated. And the condition on that is that any profit seen off of that patent, and this is obviously subject to whatever agreement is made with the university. But traditionally, they publish on their website that they expect 75% of profit to go to the researcher and 25% of profit to go to the university. And I did a little bit of an environmental scan in terms of how this kind of fits in, and this is very typical. So in the case where you were doing something at the University of Toronto, they would have a very similar funding exchange, except you would not have the option because they shared the IP with you. Whereas here at the University of Waterloo, you have the option not to pursue that pathway and independently go on your own. So what Waterloo enables you to do is choose basically how involved you want the university to be in pursuing commercialization. And at the very minimum, they offer that consultation and that support in the early process before you commit to having them own part of your IP. So they give you a lot of services in that manner. And then the last and important thing to mention, especially about researchers and especially researchers who are looking at commercialization, is that public disclosure prior to filing for patent protection can negatively impact your ability to secure patent protection. And in some cases, public disclosure might include the regular academic behavior of publishing your research in a journal, or submitting conference papers, or doing conference presentations. All of these things can count as public disclosure, and that may prevent you from filing a patent. And so something that the Waterloo Commercialization Office will do is consider the public disclosure of your research up until this point, and help you evaluate whether or not a patent is possible based on that public disclosure. So they help you consider some things that may be very difficult to try and interpret on your own, such as public disclosure. But yeah, okay. I'm going to move on to intellectual property and coursework. So we have probably heard of a lot of the academic integrity obligations in terms of sharing questions and solution sets for assignments and quizzes, but there is also an intellectual property obligation there as well. So inappropriate use of the intellectual property of others provided in coursework could be an academic offense. And coursework IP at the University of Waterloo is considered any lecture content, which includes videos, handouts, presentations, and course notes. The question and solution sets for any assignments, quizzes, tests, exams, and that is content that is owned by the instructor, and it is important to recognize that the instructor owns that content, because an intellectual property violation, such as sharing the materials publicly online, and third-party tutoring is not permitted in terms of the intellectual property framework that we have here at the University of Waterloo. So the things that you can't do with your instructor's content is create share notes with people outside of the course, submit content to services like Course Hero or Chegg, things like that without the instructor's permission. You are expressly forbidden from doing something like that. And if you do something like that and it can be traced back to you, there is a potential for academic offense ramifications. So your instructor owns the copyright and the materials they've prepared for class. And if you want to share the materials outside of the class, you should, and in fact, you must ask for permission first. It's also important to recognize that your instructor may not have used solely their own independent intellectual property. And so you might be treading on other intellectual property matters, such as journal articles or book chapters, where the instructor has permission to share them within the university context. But once you go about sharing them, that's a different sort of intellectual property violation. And so it's very important to make sure that you understand where the information you're sharing is coming from, and that the instructor grants permission for any sharing that you do. More fun intellectual property in coursework in courses that you teach. So IP generated for teaching activities is generally, just like the other stuff you do at the university, owned by the creator. Here we see the administrative teaching materials exception. So the exception is that the university told you to create a course outline, so you created a course outline, and because that is an administrative activity that you did for the University of Waterloo, they own the course outline. So your course outline is not intellectual property that you own, it is intellectual property that the university owns. However, any detailed teaching materials, such as your course notes or your lecture, or your handouts that you've generated, those are yours because you made them and they're your detailed teaching materials. The condition, and this is our exception 3 on our creator-owned intellectual property and coursework, the condition for you owning your teaching materials that you've created for your course is that they have to be available for royalty-free use for teaching and research by the members of the university. So the university basically says you can own all of your teaching materials as long as we don't have to pay you for them beyond the money that we're already paying you to teach the course. And that honestly seems like a pretty sweet deal. It also seems like a pretty fair deal. You're teaching a course. Why should the university have to pay you for teaching a course that they're already paying you for? So it seems like a very good common sense principle. And so now we've covered our 3 exceptions. You own your intellectual property unless it is an administrative material that you've created, unless you have a contract with an outside company that they own some of the IP, and accept that the university gets royalty-free use of teaching and research materials that you've generated in the course of teaching at the University of Waterloo. And in terms of teaching and sharing resources with the students that you are given this opportunity to share your knowledge with, the University of Waterloo Copyright Office emphasizes again that obligation to respect other people's intellectual property. And so they recommend when using external content that you consider open licenses or public domains, so stuff that is free and fair to use, that you try and make use of the library licenses. And so you can use anything within the university's library portfolio that they offer to lecturers. And also they emphasize the fair dealing principles of copyright law in Canada. So in public universities in Canada, you may reproduce short excerpts, so less than 10%. They've got a list of things that qualify as a short excerpt. And if you are trying to do fair dealing, I would suggest looking up the fair dealing memo that they published. There's a link to it in my references. So a chapter of a book or less than 10% of a textbook or something like that. These all count as short excerpts from a copyright protected work for the purposes of research, private study, criticism, review, news reporting, education, satire, or parody. So I expect research, private study, criticism, review, and education to be all things that fall under teaching in the teaching and courses. So you're allowed to use up to a certain part of a copyrighted work, like a textbook or something, and publish that or hand it out for study. And that's an important principle to know, because it can I've known a lot of really good content be shared in classes under the fair dealing principle. In terms of where to find more information, so here we've barely scraped the surface of the depth of intellectual property, but I hope that I've given you a good foundation in terms of navigating intellectual property here at the University of Waterloo. We covered coursework in terms of respecting the IP of others and also what you do and do not own. We've covered research, both in the terms of respecting the IP of others, the exceptions to IP regulations, and what you do and do not own. And we talked a little bit about commercialization. So where you can find more information on courses, teaching, or writing your thesis, Copyright at Waterloo. They have a website with a lot of frequently asked questions and other helpful resources in terms of navigating intellectual property use at the University of Waterloo throughout many of your activities. And they are quite a good resource. And then with help with commercialization, patents, and other things associated, the Waterloo Commercialization Office can also be found. They're there to help you, walk you through the process of commercializing, because it looks very good for the University of Waterloo when you do commercialize your project. So they're happy to help you through that process, and may even be able to file the patent for you if that's something that you wish for them to do. Thank you for coming. I will be accepting questions, but I also want to highlight a couple good resources here. So we've got our fair dealing advisory at published by Copyright at Waterloo that can help you through the fair dealing principle. And then we have Copyright and Your Thesis, also published by Copyright at Waterloo, and they cover a really good high level summary of recommendations when you're writing your thesis. Excellent. Thank you so much. I'm awesome. Okay.